Herein is the Alize of 1954 and another.
Well, Mr. Hill, I think I'm just about organised now. We're still waiting for those of us who take notes with a pen and paper, are waiting for notebooks. Thank you, Derek. Yes, so we're now ready. Mr. Hill.
May it please the Court. I appear on behalf of the appellants, who are the owners of the container ship CMA Libra. I appear together with Mr. Carlos and Mr. Payne, and my learned friend Mr. Russell, Queen's Counsel, and Mr. Hoffer appear on behalf of the appellants. In 2011, the Libra grounded, and the owners claimed general average contributions from the owners of the cargo carried on board the ship. As set out in the statements of agreed facts and issues, 92% of the cargo interest paid there, but 8% received. And those cargo interests are the respondents in this. Cargo interests say that they do not have to contribute because the owners were in breach of the relevant contract of carriage. In particular, they allege that the owners were in breach of their obligation to exercise make the vessel seaworthy. This obligation, as you will know, is contained in Article 3, Rule 1 of the Hague Rules, as an international maritime convention that the parties chose to incorporate carriage. There are other international rules, such as the Hamburg Rules, Rotterdam Rules. They are more onerous for ship owners. But the parties in this case chose to incorporate the Hague Rules. They actually remain the most commonly incorporated. At trial, cargo interests made a large number of different allegations of unseaworthiness, including that the owners had failed to properly man the vessel because the crew was incompetent, and that the vessel lacked appropriate safety systems on. The single allegation that succeeded was that the passage plan was defective. All the other allegations failed. And it's against this background we say the central issue is whether a carrier that equips a competently manned vessel with all the crew that may be needed for safe navigation of the ship and discharges its obligation, does it discharge its obligation to exercise due diligence to make the vessel seaworthy by properly equipping the vessel, even if that results in a defective passage plan. Now, owners' cases, they've discharged their obligations for two reasons. The first reason is that a defective passage plan does not, in and of itself, render a vessel unseaworthy. The passage planning is navigating, and navigating a ship is in a different category from seaworthiness, which denotes a ship's capacity or fitness to be navigated. The second and alternative reason is that any negligence by the master in passage planning, which is singularly and exclusively his or her responsibility, does not amount to a failure by the carrier to exercise due diligence. Carrier discharges its obligations as regards passage planning by properly manning and equipping the vessel with all that the master may need for passage planning, but having done so, it's not responsible for the master's failure to do so. Now, these two reasons correspond to our two grounds of appeal, namely that the courts below were wrong to hold that the Libra was unseaworthy, or alternatively, if the Libra was unseaworthy, they were wrong to hold that owners had failed to exercise due diligence to make her seaworthy. Now, my lady and my lords, we say the court below has disturbed the allocation of risk as between carrier and cargo. That bargain was settled long ago in 1924 when concluding the Hague Rule. Under Article 3, Rule 2 of the Hague Rules, a carrier has an obligation to carry the cargo safely and carefully. Negligent navigation causes loss or damage to the cargo is a breach of that obligation, the bailment obligation. But since Time immemorial, and I'll come to those words later, ship owners as carriers have been exempted from negligent navigation. This was a risk to be insured by cargo. However, by a process of reverse engineering, cargo interests now say that the navigational decisions, so long as they are taken before the commencement of the voyage, can in of themselves render a vessel unseaworthy and amount to a breach of Article 3, Rule 1. We say this evades the risk allocation, which has been well established, by bringing into the scope of Article 3, Rule 1, what would otherwise be an error of navigation and therefore fall clearly within the exceptions to Article 3, Rule 2. We say, as the International Group of P&I Clubs set out in their application to intervene, the decision has clearly caused a lot of consternation. It's been relied on with considerable frequency. In March this year, the group estimated that the total value of claims concerning passage planning that had been received by the IG member clubs since the decision of the Admiralty Court in this case is in excess of $116 million. The decisions of the lower courts have thus, we say, increased the scope of the contractual duty of seaworthiness. Specifically, there is a real concern that the Court of Appeal judgment upsets the division of responsibilities between shipboard and shoreside staff and leave to ship managers involving themselves in navigational decisions. Now, after addressing the facts, which I'll go through briefly, I will make 4 submissions, and they're set out in a roadmap that we sent to the court, which we hope the court's got, but we've got copies if it doesn't. Our first submission is that the Hague Rules, when read in their context and in the light of the treaty's object and purpose, show that there is a category-based distinction between a vessel's quality of seaworthiness or navigability on the one hand and the crew's act of navigating. Our second submission is that this reading is reinforced by English and American precedent. The cases show that a vessel is seaworthy if she is intrinsically seaworthy and in all her attributes fit for purpose. Any defect has to be an attribute of the vessel. The third submission is that applying this framework, passage planning is an integral part of navigation and therefore outside the ambit of seaworthiness. Finally, my fourth submission will be, and it's an alternative obviously to the third, that even if a defective passage plan is a defect that renders a vessel unseaworthy, such unseaworthiness is not the result of a failure by the carrier to exercise due diligence, because the carrier's due diligence obligation vis-à-vis passage planning is not an absolute obligation to ensure a flawless passage plan. It is to exercise due diligence to enable proper passage planning to be undertaken. And with that introduction, I'll move on to the facts of this case. Now, we say the facts of this case matter because they demonstrate that passage planning is an integral part of navigating. Libra is a container ship. She loaded and discharged containers at Xiamen in China, and her next port of call was Hong Kong. The master and the second officer planned the voyage from berth to berth, which included passage out of the port of Xiamen to open sea. This involved transiting a buoyed fairway. According to the passage plan, the vessel was to remain in the buoyed fairway at all times. Had the vessel actually remained on the planned track, she would have safely navigated out of the fairway into sea. The planned track in the passage plan was perfectly safe. However, what in fact happened was that during the actual transit down the fairway, the master, on the spur of the moment, took a decision to depart from the planned track. This caused the vessel to ground about 1 kilometre outside the fairway. Now, the judge found that the master should not have done so, and his decision was negligent. Don't undermine that at all. It is common ground, we say, that if this had been the only cause of the grounding, the carrier would not be liable. The cargo interests would have, cargo interests would make a claim, but owners would have a defence to that. Or if, in fact, it's the other way around and that cargo, that owners bring a claim for GA, cargo would have no defence to the claim for GA. However, the judge made the following findings of fact that led him to conclude that the vessel was unseaworthy. He held at paragraph 73 of his judgment that the crew should have, as part of the passage planning exercise, annotated the working chart, and I'll come back to the working chart in a moment, annotated the working chart on which the route was planned, with a warning added by hand that, and the warning is, numerous depths less than charted exist within and in the approaches to Jiangmengang. I'm going to call that the depths warning, so I don't keep reading it out. He found then, had the passage plan contained that warning, the master would not have made his negligent decision to depart from the planned track out of the fairway, and that the passage plan was defective and it was a real and effective cause of grounding. Now, the decision by this court will, of course, have much wider implications merely than the facts of this case. A passage plan can be defective for a whole host of reasons. It may lack navigational warnings, but it may also contain the wrongly marked track on the plan. It may contain the wrong waypoints. It may contain wrongly marked speeds for a particular section of the voyage. There's a whole host of reasons why a passage plan may be defective. Now, if I can show you some documents at this stage. The uncharted depth warning was contained in a notice to mariners, which was on board the vessel, as found by the judge. And you'll find the notice at tab 14, it's page 232. Just to introduce this, notices to mariners are issued by a number of different sources, such as the UK Hydrographic Office. And notices to mariners contain navigation information, such as chart updates, changes in voyage, things like that, temporary dredging going on, port closures, that sort of thing. They can concern permanent matters or temporary matters. Now, if we look at this relevant notice to mariners, it's number 6274P, and you'll see towards the bottom of the page, it starts 6274P, and you'll see paragraph 2, numerous steps less than charted exist within the approaches to Jiangmengang, and it actually goes on. The most significant are as follows, and in fact none of the further particulars are relevant on the facts of our case. And that is the depth warning that the judge said should have been written in the passage plan. And you'll see, if one just goes over the 2 pages to 234, paragraph 16, and I'll come to this later, it says the former notices to mariner 705P is cancelled. The other notices to mariners are at pages 235, which is tab 15, and 237. I'll do 235 first. This contains a notice to mariners 6275, and it requires, and you'll see, it's in the middle of the page, it requires chart 3449 to be amended and the legend on the chart to be crossed out, and it says C, notice to mariners 6274P, which is the one we just looked at. And if one turns over the page, at page 236, what the Hydrographic Office actually gives you is a tracing that you print out on tracing paper, and then you go to your physical chart, and then you'll see it tells you what to do. You lay it over your chart, and you'll see in both boxes, CNM, the 705 has been crossed out, and you're supposed to write in 6274. So the chart itself tells you to see the notice to mariners that contains the depth warning. And they actually tell you exactly how to amend it to refer to the new notice to mariners. The second one of some relevance is at page 237, and this is notice to mariners 1691. And you'll see it requires, for example, the chart 3449 to have various depths inserted or contour lines inserted and others deleted. And again, if one goes over the page to page 238, you'll see that there is a tracing given. What happens, you print it off on tracing paper, you lay it on top of your chart, and it tells you precisely how to amend the chart. And the judge refers to these and finds that the chart had actually been properly updated and corrected. And that's at the judge's judgment at paragraph 117. Just pausing there, it's worth noting that no notice to mariners actually required a crew to write the depth warning at the top of the chart. Now, I should say something about passage planning. There are standard guidelines in relation to the practice of passage planning, and passage planning is not a new concept. In 1973, the IMO referred to passage planning in its then resolution. And again, in 1980, the UK's Department of Trade published extensive guidance on passage. For the court's reference, they're at pages 291, page 2224, but I won't ask you to turn them up now. The IMO regulation that was in force at the time of the grounding is the 1999 regulation, which you'll see at page 297, which is tab 23. And it's worth just briefly turning this one up. This is guidance for voyage planning, and it essentially, in large parts, repeats the Department of Trade guidance in 1980. And I just want to highlight some relevant parts. If one turns to page 298, paragraph 1.3, it makes clear there, in 1.3, that passage planning involves 4 stages, namely appraisal, planning, execution, and monitoring. Now, the first stage is appraisal, and you'll see in paragraph 2, the crew, for example, 2.1.5, the crew must use appropriate scale, accurate and up-to-date charts for the intended voyage, as well as temporary and permanent notices to mariners. So these are the sort of documents you use when you produce a passage plan. We go to paragraph 3, which is the second stage, the planning stage. Now, 3.2, this paragraph in particular demonstrates that passage planning records navigational decisions, and that's important. It records navigational decisions. Passage planning requires taking into account considerations which are routinely taken into account in navigating. For example, you will see in paragraph 2.2 onwards, you have to plot the intended route of the track or voyage or passage, including all areas of danger. That's subparagraph 1, which are normally done by hatching out areas of danger on the chart. It requires you to record safe speeds, having regard to navigational hazards and manoeuvring characteristics of the vessel. One sees over the page, it requires necessary speed alterations along the route. And it requires, for example, point 5, course alteration, taking into account the vessel's turning circle at the planned speed and any expected effect of tidal streams and currents. All these are the sorts of things that you have to take into account when planning your voyage and writing a passage plan, and they are peculiarly navigational matters. In paragraph 3.4, just briefly, the passage plan has to be approved by the master prior to the commencement of the passage. Then paragraph 4 itself is the execution stage of the plan, and then paragraph 5 deals with the monitoring stage. And it's worth noting here that during the monitoring stage, the plan may be changed. The progress of the vessel in accordance with the voyage and the passage plan should be closely and continuously monitored. Any changes made to the plan will be made consistent with those guidelines and clearly marked and recorded.
Does anything turn on the fact that the obligations are imposed on the master rather than the carrier?
Yes, my lady, it does. Very much so. And I'll come on to some SOLAS guidance as well, which requires the master not only to do it, but it requires the carrier not to interfere. And that will be in 2 documents' time, as it were. What I was going to do is just show you the passage plan in this case so that you can see where we are. It consists of 2 documents. It consists of a written passage plan itself, and it and it also consists of recordings and markings on the appropriate charts. Now, looking at the passage plan itself, one sees that at page 222, and it's tab 11. And what you'll see at page 222 is the start of the passage plan. And, for example, this page, it gives the waypoints, the courses and the distances, the courses to be steamed, and distance covered, and the like. And what that does, what happens is that these courses are reflected on the paper chart. 223 and 224 just contain separate parts of the passage while under pilotage. You'll see scrolling down other information that needs to be added to the passage plan, including tides, underkeel clearance and the like. And you'll see scrolling down to page 229, you'll see then at the end it's signed by the master. Now, what is contained in this passage plan document is also partly recorded on the chart. Now, we use the terms published chart and working chart, just to be absolutely clear. What happens is that you record your passage plan on the published chart, and that becomes, for the purposes of passage planning, the working chart. Now, it's common ground that charts used by the crew in this case was, as required by the IMO guidelines, of appropriate scale, accurate and up to date. So there was nothing wrong with the published charts. The working chart is in the bundle at page 230. In the electronic bundle is the easiest place to take it up. And you'll see what's happened is that the original working chart was lost by the solicitors in the case, and what happened was that the photocopy of the original working chart was superimposed on a published chart. Now, you'll see as part of passage planning, various pieces of information are recorded on the chart, and if you go to, it's hard to navigate, but one goes to the towards the middle of the chart, you'll see what's annotated on the published chart are things like the route, that's annotated in pencil, the plotted route, which consists of circles with a dot in it in the middle denoting waypoints and then joining up the line. There's other pencil annotations such as arrows for directions and bearings, written bearings on the document. All of this is annotating the published chart with the passage plan that is set out in the written document that we looked at earlier. Now, we understand from cargo interest's written case that there is some confusion on their part about pen and pencil distinction. Now, we should just clear that up. For the avoidance of doubt, this distinction is clear from the vessel safety management system, and the trial judge recorded that there was no criticism of owner's safety management system, and that is the safety management system contains instructions to the crew on passage planning. And what I'd like you to do, if you would please, is just turn to page 251, which is in tab 17. At page 251, this is the part of the Bridge Procedures Manual, which is the instructions to the crew for passage planning. The document starts at page 248. And what you'll see there is a requirement that, if one takes it up at the bottom of page 250 actually, the following information will be shown on the chart in accordance with the master's instructions, and it tells you what to write on the chart, and it says at the end of that, MB information will be written on the charts using pencil only. That's at the top of page 251. And then in section 7, it says in the last sentence, used charts will be immediately removed, but the courses and indications shown will not be erased before the end of the crossing and with the master's agreement. And what happens is that you annotate the chart for the particular passage, and then when you're finished and you've arrived at your destination, you rub them all out, you erase them, and that is why they have to be in pencil. And actually, it's a good indication of why actually all the annotation, those sorts of annotations, are part of passage plan. There's nothing defective in the chart. Now, the final background document I'd like to take the court to is the SOLAS regulations, which my Lady Arden, I mentioned my Lady Arden earlier. You'll see it in tab 128, page 2239. These are the IMO, this is essentially SOLAS. SOLAS stands for the International Convention for the Safety of Life at Sea. It's a very large convention. It's an international treaty which sets out minimum safety standards in relation to merchant ships. And chapter 5, which is the chapter we have in the bundle, deals with safety of navigation.
I'm sorry, I think I've picked up a wrong page number.
It's 2239.
Thank you.
Now, the first relevant regulation to look at is Regulation 19, which you'll see on page 2245. And Regulation 19 is the carriage requirements for shipborne navigation systems and equipment. And you'll see paragraph 1.1, ships constructed after a certain date shall be fitted with navigational systems and equipment which fulfill the prescribed paragraphs below. And if one turns over the page to 2.1, page 2246, you'll see all ships, irrespective of size, shall have, subparagraph 4, nautical charts and nautical publications to plan and display the ship's route for the intended voyage. The charts required as part of the ship's navigational equipment do not actually include the route, obviously, for any particular voyage. What this regulation is doing is talking about the published charts one obtains from the UK Hydrographic Office, and not the annotated chart or the working chart, which is created by the crew on board during passage. Regulation 27 is worth looking at. It's 2254, so it's going on quite a few pages in the bundle. Regulation 27 deals with nautical charts and nautical publications. Nautical charts and nautical publications such as sailing directives, list of lights, notices of mariners and the like shall be adequate and up to date. And that is, we say, the requirement on the carrier However, you've got to go a little further in the bundle to look at passage planning. If one goes to Regulation 34 at 2256. Regulation 34, safe navigation and avoidance of dangerous situations. Paragraph 1, prior to proceeding to sea, the master shall ensure that the intended voyage has been planned using appropriate nautical charts and nautical publications for the area concerned, taking into account the guidelines and recommendations adopted by the organisation. And the footnote there is to the guidelines I've already taken the court to in relation to passage planning guidelines. And then it says the voyage plan shall identify the route, and it says summarises what should be there. And then, interestingly, one has regulation. Firstly, it's an obligation, I should emphasise, on the master. And then 34.1, immediately afterwards, it says, master's discretion, owners, the charterers and the company operating the ship, or any other person, shall not prevent or restrict the master from taking or executing any decision which in the master's professional judgment is necessary for the safety of life at sea and protection of. And we say this reflects the fact that passage planning in 34, I've just read out 34.1, is, and the taking of navigational decisions are singularly and exclusively for the master, not the carrier. Now, when deciding whether the passage plan or whether the passage plan was in this case defective, Mr. Justice Tier started by approving Justice David Steele's decision in the Terepo that passage planning is not a science. There is inevitably an element of judgment as to what annotations need to be added to the chart. That's paragraph 66 of Mr. Justice Tear's judgment. Now, in a series of important paragraphs, paragraphs 67 to 70, Mr. Justice Tear then recorded various different ways in which one could reflect the depth warning that I showed you on the notice to mariners on the passage plan. And in those paragraphs, he essentially says there's three ways of doing it. He says you could write the depth warning in the pro forma passage plan document. That's the written document. He said you could write the depth warning at the top of the chart. Or he said the third way, and this was actually cargo interest experts' view, was to hatch out by scoring the chart, hatch out in pencil areas outside the marked fairway where the vessel shouldn't navigate. And hatching is a conventional way of identifying no-go areas. At paragraph 69, Mr. Justice Tear concluded that hatching chart, as suggested by Cargo's expert, was not the only way in which the passage plan could have been prudently prepared in this case. And he goes on to say he preferred the method of writing the depth warning at the top of the chart. We say the judge's analysis demonstrates that reasonable mariners may disagree significantly on both what should be recorded in the passage plan and precisely how it should be done and how the chart should be annotated for the purposes of passage planning. Now, one final point on factual matters before I move on. The point to make is the events in this case happened when it was not compulsory to have electronic charts. The position is different today. Today, a vessel such as the Libra would be required to have an electronic chart, and it would be what's on board an ECTIS system, which is a set of computers with electronic chart. Now, in that case, where today there would be no issue of manually updating paper charts like I've just shown you with the notice to mariners, where you print off a tracing paper and mark the chart. That's now all done entirely automatically because you're using a computer system which updates the base charts. However, before each voyage starts, the same information contained in the passage plan document that I showed you, namely the course lines, no-go areas, speeds for the vessel at certain points, would have to be, is and can be annotated on the electronic chart. And after the voyage is then completed, the electronic chart is wiped clean of all this annotation and you go back to the base chart. Now, what we say is the fact that we don't use paper charts anymore doesn't make this appeal OTOs. In fact, it makes this appeal even more relevant to modern day navigation. A crew today in 2021 would not be annotating a chart to update it. There will be no question of updating a chart. That updating, as I said, is done automatically. The only reason any annotations will be put on the electronic chart today is to record the passage plan. And the decision, we say, of this court will determine whether such annotations on the electronic chart can potentially render the vessel unseaworthy. I'm now going to move more briefly, I suspect, to the first topic I want to deal with, which is the methodology and the approach to construing the rules. Now, the Hague Rules, when read in their context and in the light of the treaty's object and purpose, show that there is, we say, a category-based distinction between a vessel's quality of seaworthiness, navigability, on the one hand, and the crew's act of navigating on the other hand. Now, the full name of the Hague Rules is the International Convention for the Unification of Certain Rules of Law Relating to Bills of Lading. And as the name suggests, it's to unify rules of law, and it should be construed just like any other international convention. This should not be controversial, and the approach to construction of international legal instruments is, of course, well known to this. Cargo interests, however, appear to disagree in two respects. In their written case, they say at paragraph 185 that policy consideration, and I'm quoting, policy considerations should have no role to play in this. Quite a bold statement. I'll deal with that in a moment. That's paragraph 185. And the second thing they argue, which is paragraph 119, that the travo to the convention can only be relied on where the court is satisfied that they clearly and indisputably point to a definite legal intention. And that's, we say, not the whole story and needs qualification. I'll very briefly deal with both of those 2 points. As regards the applicable principles to construing an international convention, these were most recently summarised in the Nautical Challenge and Evergreen Marine case by my Lords Briggs and Hamblin in a judgment with which my Lady Arden agreed. That case rose out of the collision between the Alexander I and the Ever Smart and called for the construction of the collision regulation. If I can very briefly just ask the court to turn up the judgment, it's at page 2095, which is tab 121. And it's paragraph 38, which is at page 2095. And it's there very clearly set out, paragraph 38. As an international convention, the collision regulation should be interpreted by reference to broad and general principles of construction rather than any narrower domestic law principles. And various cases are set out, Stag Line, James and Buchanan, Fothergill, and the like, and the Ocean Victory. Although the court was in that case concerned with the collision regulations, we say the authorities relied on demonstrate that this holds true for all sorts of international conventions. And actually the first one, Stag Line, was a Hague Rules case. And in the next paragraph, paragraph 39, my Lords Briggs and Hamblin go on to say that such general principles include the general rule of interpretation set out in Article 31.1 of the Vienna Convention. Now, we have the Vienna Convention in the bundle, and if I can just briefly take you to it, it's page 2274, which is tab 129. And Article 31.1, as I say, it's at 2274. Paragraph 1, a treaty shall be interpreted in good faith in accordance with the ordinary meaning given as to the terms of the treaty in their context and in the light of its object and purpose. I'm going to later, in about 5 minutes, do exactly that with the Hague. And then if one also looks at Article 32, as we'll come on to this for Cargo's case, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning, and I'll go slowly there, in order to confirm the meaning resulting from the application of Article 31. So just pausing there, so you can look at it to confirm the ordinary meaning of the words, or to determine the meaning of when the interpretation according to Article 31 leaves the meaning ambiguous or obscure or produces absurd or unreasonable results. So that article itself distinguishes between recourse to the travo for 2 different purposes. Confirmation of the meaning is the first one, and determining the meaning is the second one. We say that the travo have been or should be used in the present case, or only needs to be used to confirm the meaning. So there are no preconditions to having any recourse to them. If necessary, if you really feel there is some ambiguity, we will rely on the second part, but we say actually you're only looking at it to confirm the meaning. Now, cargo interests cite in their written case, at paragraph 119, English cases for the proposition that the travo cannot be referred to unless there is a clearly and indisputably point to clearly and indisputably point to a definite legal intention, and that's written without what they've written. They relied both on Fothergill and the Yanis NK which were cases where a party tried to rely on the travaux to resolve what they said was an ambiguity. So they were the second limb cases, when it was admitted in those cases that there was an ambiguity, and they then tried to rely upon the travaux. And it was in that context that the courts essentially held that the meaning of a provision in an international convention which is ambiguous, the court is not going to be held with travaux which is ambiguous. So it makes sense that it does, we submit, is entirely unremarkable. We say this does not affect the correct approach when you look at the travaux for the first reason, which is confirm the ordinary meaning of the word. If necessary, I'll come back to this in reply. I'm not going to say any more at this stage. I'll see what my learned friends say. So this leaves me now to deal with cargo interest comments on policy consideration. And because cargo interests deal with this in 3 short paragraphs in their written case, it's actually helpful if you could turn up their written case. You'll find it at page 111, which is tab 3 of the bundle. And under a heading section D, public policy, they have 3 paragraphs. Paragraph 185, they say policy consideration should have no role to play in this appeal. Now, if by this they mean that the object and purpose of a treaty is relevant to its construction, then with respect they are wrong. They go on to say that the judge, so they go on to say that the task for the judge was not to make policy, but to apply the provisions of an international convention, as those provisions have long been understood in English law. But we say with respect that's not quite right. The very first case cited by my Lords Briggs and Hamblin in the Evergreen case was Stagline. And that was a case about the Hague Rules. Although I won't ask you to turn it up now, I'll just, for the court's notice, page 739 of the bundle. In that case, Lord Macmillan said that the Hague Rules have an international currency, so that it is desirable in the interests of uniformity that their interpretation should not be rigidly controlled by domestic precedents of antecedent date, but rather that the language of the rules should be construed on broad principles of general acceptance. And we set out that quote also in our written case. Similarly, Lord Clark in the Ocean Victory, which is again another case in the bundle, and you'll see it for your notice, 2164, but I won't ask you to turn it up now. Lord Clark in the Ocean Victory, when construing the Limitation Convention, said that this should be done without any English law preconceptions, because the interpretation of conventions must not be controlled by domestic principles, but by reference to broad and general principles of construction. So that's what I want to say about their paragraph 185. As regards paragraph 186, Cargo say that there is an obvious public interest in encouraging ship owners and their vessels to be properly equipped. Now, we say there are 2 problems with that analysis. The first is that it elides an amorphous concept of public interest with what we should be looking at, which is concrete issues of context, object and purpose of the treaty in accordance with Article 31 of the Vienna Convention. We say that is what you should be looking at, and I'm going to do so, as I said, in a few moments. Cargo interests, we say, don't engage with that. Secondly, this is not a case about a ship that was not equipped with all that was necessary to enable her safely navigated. I really do want to stress this. Cargo tried to run that case at trial before Mr. Justice lost. This ship was properly equipped. It had all the right charts, notices to mariners, all the right equipment, and the crew were competent. They alleged my master was incompetent, and he was found to be competent, and it had all the right equipment on board. So what we say is, in circumstances where owners have done everything they possibly could do, and in circumstances where this was a one-off error rather than part of some systemic failure, The question then becomes, should the carrier still be nevertheless liable? I'm going to take the court later to some comments of Lord Diplock in relation to the underlying purpose of the Hague Rules was ensuring risk. We say that will be met with those comments. The final paragraph of cargo interest written case is perhaps the most important one. It's paragraph 187. They say that there is no reason to relieve the carrier from liability where the relevant error is on the part of the master or navigational officer, i.e. the employee of the ship owner acting in the course and within the scope of their employment. So what they're saying there is there's no public interest in letting off a carrier when it's his own servants who have been negligent. Now, we say this is really the crucial difference between the appellants and the respondents, because the relevance of the crew having been negligent, we say, underlines both grounds of appeal. Now, as I hope to demonstrate in my next section of submissions, it's precisely in the case of a navigational error by the master and navigational officers that the carrier is relieved from liability. That's what the rules. We say construing the rules and looking at precedent demonstrates that this is because such errors in navigation are a risk cargo interests have agreed to assume, and a risk against which cargo interests assure themselves. And that is well set out in the rules. I'll therefore go on to my next section, which is actually construing the rules themselves. And we say this division of insurance risk is obvious from three things: text of the rules, context, that is together with the object and purpose of the treaty, and then thirdly is confirmed by the trap. So I'm going to do three things. One, I'm going to look at the actual words used, the ordinary meaning of the word. Secondly, I'm going to look at object, purpose, and context. And thirdly, I'm going to look at the travo just to confirm what I've said already. Now, before I go through those three steps to construing Article 3, Rule 1, perhaps helpful to set out the parties' rival positions and what the court is having to construe. Owner's position is that one first must construe what amounts to seaworthiness. Specifically, what defects are capable of rendering a ship unseaworthy, and whether they need to be an attribute of the ship. We say that has to be done before addressing any other questions, such as when does the ship need? There's a big difference between temporal point, and the actual concept of seaworthiness itself in isolation. By contrast, cargo interest case and the temporal distinction which they make assumes that any defect is capable of rendering a ship unseaworthy without any limitation, so long as it would have been made good by the prudent owner, and importantly, whatever type of defect it is. Cargo owner's position is that liability therefore solely turns on when the defect. And that's really the competing cases of the parties. Now, if cargo's position is that the same defect renders a vessel unseaworthy if she is in port, but would not amount to unseaworthiness if she's already left port and on her voyage, we say this would be obviously wrong. Defect either renders the vessel unseaworthy or it does not. It cannot depend on when. If the vessel is rendered unseaworthy, then the next question is whether the carrier is liable for such unseaworthiness. And we accept that that will involve a temporal issue under the Hague Rules, but actually not necessarily under other contracts that incorporate the concept of seaworthiness differently. To the extent that it is cargo interest case, that one of the reasons why liability turns on when the defect occurs is that a carrier can only avail itself of the exceptions in Article 4, Rule 2, if at the commencement of the voyage the vessel is seaworthy. That is entirely common ground, and we owner's case is not, and I really should stress, has never been, that the vessel was unseaworthy at the commencement of the voyage, but they are not liable because they can avail themselves of an exception. Owner's case is simply that the vessel was not unseaworthy because a defective passage plan is not a defect which is capable of rendering a ship unseaworthy. And just to be absolutely clear, we say the exceptions in Article 4.2 are only relevant to the extent that they provide the relevant context for the construction of the word seaworthiness, Article 4. And they help identify the object and purpose. Now, I can start by looking at the ordinary meaning of the text, and it's therefore useful to have the text open in front of us, and we can see it at page 303, which is tab 24. And on this page, you'll see Article 3.1. And the first point we make is that looking at the French in the left-hand column, seaworthiness was translated as literally état de navigabilité, or the state of navigability, or navigable condition. So we say, accordingly, the carrier has to put the vessel into such a physical state as to enable her to be safely navigated.
Can I just confirm, are both language versions equally authoritative?
No, it's the French that is the authority.
And where do we find that?
I'll give you the case reference. It's India, Prince India. It's tab 48, page 691. Those behind me will give me the page reference for where that's at.
Thank you.
We say, by contrast, and if one looks at Article 3.2a on page 306, by contrast, Article 4.2a covers actes, négligence or défaut dans la navigation. And we say it's directed at what the crew does with a ship that is already in a state of navigability. We say this makes express the critical difference between seaworthiness, which we say is about equipping the ship with everything that may be necessary for the vessel to be safely navigated, and then the use of that equipment. Just for my Lord reads a note, it's page 710 of the bundle, and it's paragraph 68, subparagraph 1 of our written case.
Yeah.
We say, put simply, a vessel is seaworthy if she is in a state that enables her to be navigated safely. An alternative formulation, which reflects the way in which the implied term of seaworthiness was initially formulated in the 19th century, is to ask whether the vessel is fit for purpose. That's actually how the implied term of seaworthiness developed in the 19th century. And it's actually worth going back to that. Is the real question about seaworthiness is she fit for purpose? In this regard, then, the question becomes whether the ship is fit for the purpose of navigation. We say on either formulation, the focus of the inquiry is necessarily on the state of the vessel. What matters is what is intrinsic to or an attribute of the vessel herself, as opposed to something extrinsic or ephemeral. Now, the relevant attributes of the ship are actually expressly defined in Article 3.1. If one goes back to page 303, you have a number of subparagraphs. The attributes of the ship are the ship herself, subparagraph A, the crew, equipment and supplies on board the ship, subparagraph B, and the holds and other parts of the ship in which the goods are carried, subparagraph C. And we say, furthermore, as a matter of language, Article 3.1 does two things. It provides that the vessel must be in a seaworthy state, but it also specifies at what point in time the vessel has to be in a seaworthy, namely before and at the commencement of the voyage. Now, as we've explained in our own written case at paragraph 96, time and seaworthiness operate at distinct logical stages of the analysis. And our case in summary is that the meaning of seaworthiness cannot turn on when the defect happens to manifest. The undertaking in the Hague Rules provides that the vessel must be seaworthy before and at the commencement of the voyage. But it is only once the logically prior question of is the vessel seaworthy has been answered in the negative that one turns to the secondary question, which is when was the vessel not? Indeed, we assume it's common ground, but the charter parties, some charter parties routinely provide for continuing obligations of seaworthiness. For example, the Shell Time 4 charter party does so, requiring her to be seaworthy on delivery and throughout the period of the charter. Such a charter party often are often incorporated into contracts of carriage, into bills of lading. So what we say is whatever answer the court gives on this appeal, it's going to have to work in all these scenarios, including when you have a continuing obligation of seaworthiness. And we'll come on later, perhaps, for a short adjournment. What happens if the master amends his passage plan? Owner's case is that, regardless of whether the intention is written down before or after the vessel leaves port, it is an exercise of navigation. And navigational decisions do not render the vessel unfit to be navigated. Ultimately, the word the court has to construe, as we said, is seaworthy. And we say the critical difference between the parties is whether, as owners argue, it means navigable, and therefore not all defects are capable of rendering the ship unseaworthy, or whether, as cargo interests say, it encompasses any and all defects so long as they just simply meet the McFadden prudent owner test. So that's looking at the ordinary meaning of the words in the text itself. I now want to move on and look at context, object and purpose. That's the second part of Article 31 of the Vienna Convention.
I'm just reading what Mr. Justice Devlin said in the passage that you referred me to. I don't want to take up time unnecessarily on this, but all he says is that it's permissible to look at the French text. But his approach is that the convention, the rules take effect, well, the convention takes, because we haven't even got the whole of the convention, but it takes effect in English law via its incorporation in the by the Carriage of Goods by Sea Act of 1924, and it's in the light of the preamble to the act, to that act, the 1924 Act, which I don't know if we have that, and the fact that the French text is the only authoritative version of the convention, but he thinks it's permissible to look at it.
I'm grateful that the French text is the only authoritative version of the convention. There may be a difference if it's, for example, we have it incorporated under an Act of Parliament in this country, but in most bills of lading, it will be incorporated for other reasons, not necessarily domestic legislation. The parties can, and quite often do, contractually choose to incorporate.
Is that right?
Yes.
The Act doesn't require them to incorporate the convention into the rules, into the bill.
It depends on the port of shipment and the port of delivery and all sorts of factors. But in many cases, the bills of lading just also contractually incorporate the Hague Rule.
Well, I haven't seen the Act, I haven't seen the bill of lading, I haven't seen the entire text of the convention, except having looked it up myself. I don't know if we have any of these in the bundle.
Can I come back to that maybe after a short adjournment, when I can assist my Lord Reed more at that point? If I can go to then context, object and purpose. We say the context, object and purpose of the Hague Rules make clear that seaworthiness is not some amorphous concept that embraces any and all defects. We say the best explanation of the context and purpose is actually given by Lord Diplock in an article which he wrote some time ago, which you'll see at page 1934. It's tab 110 of the Bible. I'm just going to ask you to turn that up. This is an article dealing with maritime conventions, and what he does is it's conventions and morals, limitation clauses, and international maritime conventions. And he introduces the issue of insurance. He basically says maritime conventions are all about insurance. And he introduces that at the bottom of the first page, 1934. And he says, I'm taking it up halfway through the middle paragraph. It is not the actual sinner who pays for the consequences of his sin, but in the courtroom, as at the diplomatic conference table, we talk and tend to think of it as a contest involving a moral conflict about one human being's duty to his neighbour, instead of an allocation of liability between cargo insurers, protection and indemnity, P&I insurers, of a loss which has occurred through the fault of neither. This, and not more, what international conventions relating to the carriage of goods are about. And that's going to be a theme that gets built on when one looks at the Traver. Now, if one turns over the page at 1935, Lord Diplock argues that this allocation is made more efficient by the unification of bills of lading. And if one takes it up at the bottom of page 1935, the introduction of additional parties with economic interest in the transaction of carriage, facilitated by the general adoption of contracts of carriage between the cargo owners and the carriers, terms of which are uniform so far as their respective rights and obligations in loss or damage. Quite important today, unification of how all courts. The use of a standard contract of carriage enables carriers to offer standard rates of freight and insurers to quote a premium without incurring the expense and delay involved in examining the detailed terms of each individual carrier's liability and goods which they insure. And then with that background, well, actually, if one just moves over to the bottom of that page, that's 1936, I'm reading about a couple of inches up from the bottom on the right-hand side. It starts, the terms of the standard contract of carriage should therefore impose upon the carrier a liability for loss or damage to the goods sufficient to provide him with a commercial inducement to undertake precautions, the cost of which would be economically justified by the reduction of the risk of loss or damage. Then, moving over the next sentence, apart from one other factor, the only function of the clauses of a standard contract of carriage will define and limit the liabilities of the carrier for loss or damage to the goods while in his custody, provide that inducement. Now, against this background, Lord Diplock explains the reasons for the error of navigation and management exception in the rules. And it's worth just picking it up at 1937, the bottom paragraph. The paragraph starts by talking about the 1968 conference, which was there to amend the Hague Rule. And he says, in the middle of that paragraph, surprisingly enough, there has been no criticism of the immunity of the carrier from liability for loss due to negligent servants in the navigation or management of the vessel. Indeed, an amendment was accepted which extended this immunity to negligence itself. It goes on, since negligence in navigation and management would be likely to endanger the vessel as well as the cargo. This in itself is sufficient inducement to take precautions to prevent it, and it is more practical and economical from the point of view of insurance to spread the risk to the cargo among a number of cargo insurers than to concentrate it in the carrier's P&I insurer. And that point actually is made good when one looks at the third stage and one comes to the Travo, because that very point is made during the Hague Conference. A very similar point was actually made by the Supreme Court in the New Zealand in the Tasman Pioneer case, which we've referenced in our written document. Now, in relation to navigation specifically, the allocation of risk in the Hague Rules is as follows, we say. The carriers have to insure themselves against the risk of all damage to their own ship and damage to the property of third parties, such as other vessels, structures of the port. So if you negligently navigate a vessel and you hit another vessel, the owner has to insure against that risk, and he has to insure against damaging port structure. Cargo interests have to insure themselves against the risk of negligent navigation causing damage to the cargo. And we say that is the bargain that was struck. In this regard, the fact that errors in navigation almost always result in damage to the ship herself or some other liability, to, for example, a jetty, demonstrates that this is not a case where it is important to deter carriers or incentivize them to prevent errors in navigation. Thus, to the extent that deterrence is another policy reason often used in the context of vicarious liability, it doesn't apply here. Put simply, avoiding damage to the ship that inevitably results from any error in navigation is incentive enough.
Doesn't Lord Diplock's argument prove too much? I mean, it's in the interests of the carrier to make sure the ship is seaworthy, otherwise going to sink or suffer damage. So you might say, well, that's incentive enough, and spread the risk.
I see the point. I can see that point, but what actually happens, and I'll come on to it in about 5 minutes, when one goes through the Travo conference, this very point was considered. And in fact, we make clear that at the time of the conference, it was decided that cargo are best placed to insure for damage to the cargo, but provided that the vessel is made seaworthy to begin with. And that was the bargain struck. And maybe if I can come back to this point in about 5 minutes. Now, the bargain was struck against a historical background that a carrier had to exercise reasonable care for the goods. This is recognised, or was recognised, by the Supreme Court in the Volcafe decision, which I won't ask you to turn up now, but it's page 1557, paragraph 8, where essentially, as a Bay law, Lord Sumption said ship owners had to obviously exercise reasonable care for the goods. Now, the Hague Rules largely preserve this fault-based liability. And if I can ask the court to go back and look at the Hague Rules themselves again at page 306. This is Article 4.2, which sets out the exemptions. And again, I say I'm looking at the exemptions merely to give context to the obligation in Article 3.1. The most important exception is exception Q at the bottom of the page, which excludes the carrier's liability for loss or damage resulting from any cause arising without actual fault or privity of the carrier and without the fault or neglect of the agents or servants of the carrier. That's the most important exception. Now, exceptions C to P are all merely illustrations of this general principle, that the carrier is not liable for any losses that result other than because of his fault or the fault of his employees, agent. By contrast, exceptions A and B are largely, and it's for historical reasons, different, because they also relieve the carrier for liability for his servant's own negligence. And it's been long established that negligently caused fires by the ship's crew are accepted. Now, exception A expressly covers the employees of the carrier, the master, mariners, servants, or agents, and it also covers and it also covers agents, the pilots. Now, what we say, this means that exception A is in effect an exception to exception Q. So Q says you're not liable as long as neither you nor your servants or agents have been negligent. But as an exception to that exception is exception A. And we say this is confirmed by the Travo, and I'm going to, in the next section, take you to the Travo, and in particular when I actually deal with due diligence. But it's also the view recognised by the authors of leading textbooks. For example, if one looks at Scrutton, and you'll see Scrutton on Charterwise in Bills of Lading at page 1996, it's tab 114. The authors make the very same point at page 1997. Put it in context, at 1996, they cite all the exceptions in Article 4, Rule 2. And at 1997, in relation to the introductory comments, in subparagraph 2, they say, the ship owner does not enjoy the protection of these exceptions when the loss is caused by his negligence or that of his servants or agents, save insofar as protection is given under subheadings A and B. So, essentially, negligent navigation is an exception to the general exception. We say it should not be controversial that the exceptions in Article 4, Rule 2 should form part of the relevant context to construing Article 3, Rule 1. Now, we think cargo interests accept that because they accept that the meaning of due diligence under Article 3, Rule 1 excludes liability for latent defects, and that's in their written case at paragraph 166. However, just because latent defects is an exception as well in Article 4.2 does not mean that the carrier cannot rely on a defect having been latent to say that the vessel was not unseaworthy to start with. In a case where a vessel is unseaworthy, but the defect is not discoverable by the exercise of due diligence, the carrier isn't liable. The reason the carrier is not liable is not because of the exception in Article 4, Rule 2, but because there was no failure to exercise due diligence. Similarly, in this case, we say we do not say that the vessel is unseaworthy, but we can rely on an exception. Instead, we say that owners do not need to rely on any of the exceptions because the court has to read the rules as a whole. And reading the rules as a whole includes the error in navigation exception. And an error in navigation in and of itself does not render the vessel unseaworthy if she is otherwise competently crewed and adequately equipped. If any authority is necessary for the proposition that you read the rules as a whole, I'll just tell you it's dealt with in the House of Lords decision in the Yanis NK. That's a good example. I won't ask you to turn it up now, but Lord Cook says that at page 1111. At C, he says, like every legal document, the rules have to be read as a whole. It's also another good example is actually the Captain Sakharov again. I'll give you the page reference 1185, where Lord Justice Auld construes Article 3, Rule 1 against the exceptions in Article 4.2. So, reading the rules as a whole, we say it's clear that they draw a distinction between the vessel being fit to be navigated and the actual act of navigation by the crew. The carrier is going to be liable for a failure of putting the vessel into a fit state to be navigated, irrespective of whose fault that is, whether it's his servant or his agent. But once that has been done and the crew, which is otherwise competent, navigates the vessel erroneously, the carrier is not liable. That is how you read the rules as a whole. And this does not turn on the seaworthiness obligation being qualified by reference to time, i.e. the words before and at the beginning of the voyage. The point is that seaworthiness and navigation fall into two distinct categories. Now, the third area I have to look at when construing the rules is the travaux. We say that looking at the travaux confirms the submissions I've just made and confirms this meaning of seaworthiness. We say it demonstrates that Article 4.2a was an integral part of the bargain struck when the ship owners, between the ship owners and the cargo interests when they agreed the international set of rules. The trade-off was between the ship owners agreeing to the obligations under Article 3, which is the seaworthiness obligation and the bailment obligation, in exchange for the benefit of the exceptions in Article 4.2, the most important one of which was A, errors in navigation. And I'll go on to show you that one of the reasons why this was ultimately accepted by cargo interests was because it was more cost-effective for the cargo interests to insure their cargo for such errors in navigation. Now, one finds the travaux in in tab 102. It's at page 1663. And what you have in the bundle is the CMI report of in relation to the Hague Rules. Now, I'm going to look at this chronologically, which will be slightly out of sync with the page numbering. I'm going to do it chronologically because it's best to see how the arguments went. Now, in August 1921, there was an International Law Association conference in The Hague, and you'll find that at 1744. So we just note there in the middle of the page, it's the second day's proceedings, August 1921. And you'll see in the middle, just above the date, in the middle of the page, the text submitted to the conference was neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from, note the words, faults or errors in the navigation or management of the ship. Now, during the conference, Sir Norman Hill, who represented ship owners, essentially, in the P&I Club, stated the importance of the nautical fault exemption to the ship owners. And I'm just going to read the first paragraph of speech on this. This clause Article 4, ship owners. Now, sir, I would venture to remind the Commission we have dealt with cargo in Article 3, and we have agreed and accepted words that imposing the obligations on the ship. And what is more important, we have accepted Article 3 says and sets it out. That's the bailment. We have not sought to weaken or qualify those in any way. When we come to Article 4.2, our big point is the navigation. What we have asked is that we should have, which from time immemorial have certainly appeared in all British. Faults or errors have not appeared. They have been added. Our old words, neglect or defeat, master mariner, pilot or other. Our clause have our old words. Leave out faults, put in our old stead. Now, that it essentially was accepted, because if one goes to page 1747, you'll see that the text adopted in that conference in the August is, and the changes are capitalised, and the words act, neglect, or are then adopted by the International Law Commission. Now, what then happens is that there is an international shipping conference held in London in November 1921, so a couple of months later. And if one goes to 1668, earlier in the bundle, you get the report from that conference. It was attended by representatives of the ship-owning industry of 14 maritime countries, and its main purpose was to consider the adoption of. And essentially what happened is that Sir Norman Hill, having agreed the text of the Hague Rules at the August conference, had to sell it to the ship owners worldwide. And he does it at this conference in November. And if one turns to page 1670, 1670, the issue, just give you a little bit of background, the issue is freedom of contract, and the ship owner said, I should be able to put whatever I want in my bills of lading. Why should I be bound by some international rule? Freedom of contract. And Sir Norman Hill says, yeah, I'm a great proponent of freedom of contract, but you know what? We've got to do this. And this is how he sells it to the ship owners. And he says, and by the way, the words agitation, he talks about the agitation. The agitation is on behalf of cargo interests, about who should be liable for what. Starting the penultimate paragraph, the agitation has taken different phases. When I first had to deal with it, it is more than 30 years ago, the attack was mainly directed against the negligence, the one we're looking at now. At that point, we debated with cargo interests, committees of government, commissions, and frequently before the. We told our friends that they made us assume that responsibility, i.e. for errors of navigation, they would increase very substantially. That if we were to act as both underwriters and ship owners, freights must provide the funds out of met. We told them, even if we eliminated that's the negligent navigation and did assume the responsibility, their bankers would go on insisting on other policies. It is manifest that although the class of the ship may be warranty as cargo, there's absolutely no warranty as financial owner of the ship to meet cargo claims. Many times the value of the ship, so saying it there is still going to be asked, even by their bankers. The point to which I am referring was under discussion when the Harter Act was introduced. As the bill came before Congress, it contained no negligence, made the ship owner into an underwriter so far as negligent navigation was. The Senate readily inserted Section 3, which is a very fair and reasonable negligence, but it is, I venture to think, expressed in very unfortunate. Now, our British dominions followed on the lines of the Harter Act. They have all inserted negligence navigation clause. And now when meeting this new agitation, we find the cargo interests have practically all come round to our view. And they are all now maintaining that they can affect insurances against negligent navigation far more cheaply than the underwriter, than if the responsibility is put on the ship owner. They have come round to our view. And what he's essentially saying there is the background to essentially the negligent navigation exception. And this is the issue of insurance, and actually the issue of double insurance that was reflected in Lord Diplock's article that I took the court to earlier. Now, just to finish off the story, thereafter, when it got amended to include the old words as used in time immemorial. Article 4.2a was never amended for the later 3 years. So between 1921 and 1924, there was many more conferences, many more delegations, but the wording was, from that point on, never changed. And it ended up in the same terms in the final version of the Hague Rules. So we say that Travo further demonstrates that the existence of the exception was entirely tied up with the cost of insurance. Now, in conclusion on this point, we say it's important to remember that the carriage of goods by sea is fundamentally different from other instances of vicarious liability. The policy reasons for which the law of tort imposes liability on employers are well known to this court. Principally, they are that the risk that has materialised was created by the employer, who ordinarily profits from it, and relatedly that the employer is uniquely well placed to internalise the cost of insuring against that risk so that they are ultimately borne by and distributed amongst the end users. However, international trade is fundamentally different because both the shipper, the cargo owner, the shipper and the carrier both create the risk, profit from its creation, and are both equally able to internalise it. The carrier can internalise it through increased freight rates, and the shipper can internalise it through the increase in price of the goods. The end consumer is going to pay for it one way or the other, but that's not to say the end consumers are ambivalent, because they will benefit whichever insurance method is cheaper, and in particular, they don't want that there to be double insurance. In the 1920s, the position adopted in the rule was that the cargo owners would insure their own cargo against errors in navigation because they could do so cheaply. Ship owners would insure their ship against damage to the ship or damage caused to other ships or port structures. And that was the bargain struck. We say the Court of Appeal has, in this case, upset that bargain because following the decisions below, insurance risk now divided, and this is important, it's now divided no longer along the principled line of navigation and navigability, but instead, cargo insurers have to cover some errors in navigation, but now no longer other errors in navigation, i.e. those that involve writing a passage. And that P&I clubs now become liable for certain errors of navigation, but not others. And what we say is this undermines certainty and is likely to lead to inefficient double insurance. And that's the effect of the court. Now, I'm going to now move on to the next section of my submissions. I've dealt with looking at the rules, reading their ordinary meaning, and looking at the object and purpose of them. I now want to go to precedent, and I'm going to go back and look at the key authorities dealing with the meaning of seaworthiness and the allocation of liability for navigational defects.
So just before you do that, explain the general as I understand it, you accept errors of management cause unseaworthiness is a matter for which.
Yes, what I accept is that, by way of example, if you come into port, discharge your cargo, and you hit the jetty too hard, and it causes a crack in your shell plating, you can't then say, well, I'm not going to repair that, that's an error in navigation, and I can go off on my next voyage, commence my next voyage, and be unseaworthy. What we say is, it doesn't matter that the error in navigation is part of the causational background. If it results in a defect in the vessel, which is an attribute of the ship, for example, a solid hull without any cracks, then it's just part of the causational background. and you are responsible because it's the defect itself is an attribute of the vessel.
Right. But you say navigational decision in itself is something different.
Correct.
And so how do you define navigational decision in itself as opposed to consequences?
The facts of this case. So what we say, my lord, is that, and I'll come on to it when I do my section on application, but I can fast forward it now. A passage plan is simply front-loading a whole load of navigational decisions. How am I going to navigate the vessel? I'm going to go down this route, I'm going to avoid this, I'm going to be doing a certain speed in this channel. They're all navigational decisions. If you write them down in a document called a passage plan, they don't cease to be navigational decisions. They're just navigational decisions. And those navigational decisions that are sitting in a passage plan on board the vessel before the vessel leaves port they haven't resulted in any defect in the vessel, which is an attribute of the vessel. They're just navigational decisions. Whereby when you come into the berth, and I go back to my example before, when one comes into the berth and you negligently navigate the vessel and you hit the berth too hard and you create a crack in the side of your shell plate, there you've got now a defect in the attribute of the vessel, namely a crack in the side of your shell plating.
Well, the judge's findings, there's a defect in the chart, isn't there? Since you haven't got a chart that's appropriate for safe navigation as a result of a navigational decision that's been taken.
He says you've got a defective chart. We say, well, you haven't got a defective chart. The chart, the equipment provided to the vessel is a perfectly good chart. What you've got is a chart annotated with navigational decisions. And, for example, he says on his findings of fact that by not putting the depth warning at the top of the chart, that was the absence of a navigational decision. And that's why I took the hatching example. If you hatch out, another way of, instead of putting the depth warning, you could hatch out parts of the chart. If you'd hatched out the wrong parts of the chart, that's just a navigational decision. In future, when we're going to navigate on the voyage, don't go here, don't go there. That's a navigational decision. It doesn't affect the navigability of the vessel, her intrinsic qualities. It's just a navigational decision.
Even though you're going to be navigating by reference to that chart?
You are going to be navigating by reference to that chart, but we say it makes no difference. For example, if the master was... So I'll give you an example. Let's take the example of going too fast in a narrow channel. If you had put on the chart, do 6 knots, and then let's say you put on the chart, do 10 knots, and 10 knots is too fast, then it makes no difference whether the officer of the watch does 10 knots because it's written in the passage plan, or maybe even handwritten on the chart, or whether the master was there on the deck, standing there next to the navigating officer saying, yes, we'll do 10 knots going down this channel. It doesn't make any difference, the fact that it was written down, or that it was written down before the vessel commenced the voyage. It's just a navigational decision to do 10 knots in the channel. And what we say is, that's classically what cargo were insuring. Cargo, under the Hague rules, insure their cargo for damage to their cargo caused by negligent navigation. The decision to do 10 knots in that channel was negligent navigation. It doesn't matter whether the master was standing there saying to the officer of the watch, yeah, do 10 knots now, or whether it was written down in a document, do 10 knots, when you get to that point in the voyage. It's just a navigational decision. I do have a section on application, and I'll come back to that in a moment. Now, owners advance 2 principal propositions of law on the authorities. The first is that for a vessel to be unseaworthy, the defect must be an attribute of the vessel. And secondly, that defects in navigation of the ship are not attributes of the vessel. Such defects do not render her unseaworthy. Now, owners say that there are 2 Court of Appeal cases which are the modern manifestation of an established principle that for a defect to render the vessel unseaworthy, The defect must be an inherent quality of the vessel herself, or put another way, an attribute. And those two cases are the aquicharm and the apostolis. And if I just set out in advance the order of my submissions, first I'm going to look at those two Court of Appeal cases. I'm then going to review the origins of the principle, and I'm going to hopefully show the court that there are three different strands or lines of English cases, all of which have a House of Lords authority in them, which establish that principle. And I'm also going to look at the US cases which either adopt the principle or specifically deal with navigation. And when I'm looking at what we call the third strand, which is the bad stowage cases, I'll explain why Lord Justice Flo's decision below, where he doubted the apostolis, is not correct. Once I've done that, thirdly, I will then, if I have not already done so, look at the remaining cases relied on by cargo interests. And then finally, I'll look at the one case dealing with passage planning that we have, which is the repo decision, Mr. Justice Deal. Now, the modern, leading modern case on what we call the attribute issue is the Court of Appeal's decision in the Apostolis. And if you can turn that up at page 892. The facts can be briefly stated. A fire was discovered during loading. The fire ultimately had to be put out by the local fire brigade, and this damaged the cargo, and cargo interests sued the carrier on the basis that the vessel was unseaworthy. The two potential causes of the fire were welding on deck or discarded cigarette. The trial judge held it was caused by welding on the deck, and the Court of Appeal reversed this decision on the facts, holding that it had not been proved. Now, just turning to 896, which is Lord Justice Leggett's judgment, and taking on the left-hand column, just by the first black lining on against the side, nothing about the state of the ship rendered her unseaworthy. The owners were not in breach of Article 3.1 merely because welding exposed the cargo to an ephemeral risk of ignition. The holds themselves were not intrinsically unsafe. That's the way he dealt with it. It was dealt with a little bit more fully by Lord Justice Phillips. And if one goes to page 908, in addressing the issue of whether the vessel was unseaworthy because the cargo was on fire, Lord Justice Phillips articulated the test as follows. He says, and it's in the middle of the left-hand column, for a ship to be unseaworthy, or more strictly uncargo-worthy, there must be some attribute of the ship itself which threatens the safety of the ship. If a hold is dirty, that is properly considered to be an attribute of the ship. But the fact that a hold contains cargo which threatens damage to other cargo stowed in proximity is not an attribute and does not render the ship seaworthy. And he articulates the attributes principle based on two long-standing authorities. The first one is the Thorser, and the second one is the Elder Dempster case. Now, Lord Justice Phillips cites the Thorser. That's a case of chocolate had been stowed in a hold that contained a number of gorgonzola cheeses, and the cheeses contaminated chocolate. He cites Lord Justice Swinfen Eadie, and he says as follows. This is Lord Justice Swinfen Eadie, bottom of the left-hand column. In the present case, it is not contended that the ship was in any way defective in design or in structure, or in condition or equipment at the time she sailed, not the ship herself. The sole point is the way in which the cargo was stowed. It is not contended that at the date when the ship was empty and prepared to receive cargo, her condition was in any way defective, nor is it contended that the cargo was so stowed, or that any part of the cargo was so stowed, as to be a serious danger to the ship herself. The contention put forward really amounts to this, that if two parcels of cargo are stowed and one can injure the other, during the course of the voyage the ship is unsafe. I am not prepared to accept that. It would be an extension of the meaning of unseaworthiness going far beyond any report. And what then happens is Lord Justice Phillips also cites the elder Dempster, in which Lord Sumner considers that the Thorser is unimpeachable. And Lord Sumner in elder Dempster holds that seaworthiness is about the ship or some part of her being affected so as to make her less fit for purpose. And it's the fitness for purpose point. Now, the second modern statement of this
Can I just be clear that I understand what you're saying? Are you saying that charts are not part of a ship?
No.
You're not saying.
The seaworthiness includes the physical condition of the ship and also all her equipment. So it'd be her paper charts in the old days. Now it would be ECDIS, her electronic charts. It would be her compass. All of the equipment you need to safely navigate is part of the ship and has to make the ship seaworthy.
When you speak about an attribute of a ship, that has to be given a very broad meaning. This is not part of a ship.
It's not physically
in any
connected to
ordinary
the ship,
sense.
but it's been for many, many years accepted that for a vessel to be seaworthy, she has to have charts that are accurate and not out of date. She has to have a compass that works, but she has to have now electronic chart. So I accept that. It's easier to say it today because actually today your electronic chart is actually part of the ship. It's a computer built into the ship. Now, the second modern case is the Aquacharm, which you'll see at tab 59, which is page 919. Now, this was an arbitration appeal against an award of Mr. Justice Thornton. The judge at first instance was Mr. Justice Lloyd, and the case was argued actually by Mr. Phillips, as he then was. In short, the master loaded too much cargo at Baltimore bound for Tokyo, such that she could not safely transit the Panama Canal without being lightened. If she did, she was going to ground. The case concerns seaworthiness in the context of a time charter which incorporated the Hague Rules, and we say that it's irrelevant that it was a time charter. The relevant part of the case for present purposes is whether the vessel was unseaworthy when she left the load port in breach of Article 3.1. And Lord Denning says this, you see it at 922, at the bottom at H. Both the umpire and the judge found that the vessel was seaworthy. I agree with them. I think the word seaworthy in the Hague Rules is used in its ordinary meaning, not in any extended or unnatural meaning. It means the vessel, her master and crew, is herself fit to encounter perils of the void, and also that she is fit. The vessel was so fit, maybe that she had to be lightened, passed through the canal, but that did not make her unfit. And then we have Lord Justice Griffith, at page 925, and reading between E and G. As I understand the authorities, there are two aspects of seaworthiness. The first requires the ship, her crew, and her equipment shall be in all respects sound and able to encounter and withstand the ordinary perils of the sea during the contemplated voyage. The second requires that the ship shall be suitable to carry the contract cargo, Elder Dempster. The Aquacharm at all times fulfilled this first requirement of seaworthiness. There is no suggestion that her draft was such as to put her at a risk in a heavy sea or to render her in any way unsafe to sail in. The Aquacharm also fulfilled the second requirement. It was a suitable vessel to carry a cargo of coal. The reason why she could not enter the Panama Canal was not because she was unsuitable to carry a cargo of coal, but because the master had loaded the coal so that the Aquacharm down by the head when she arrived at the canal and possibly loaded too much coal. So it's a decision of the master. The Aquacharm was delayed because of bad stowage, not because she was unseaworthy. And finally, Lord Justice Shaw at page 926, firstly between E and F, I would only enter my own caveat against any artificial extension of the business, where that term is used in relation to the carriage of goods by sea. And then at H, While these submissions appear superficially tenable, they cannot survive critical. Seaworthiness connotes an inherent quality with which the unit comprising the vessel and cargo is, as long as that unit quality remains. External factors influence or affect innate attributes. And if one steps back and looks at the facts of this case, the vessel couldn't have gone through the canal without grounding, or at least a serious risk of grounding. If one had done simply what cargo interests in this case say, you just say, simply ask the prudent owner test whether the prudent owner would have remedied the defect before sending his vessel to sea back in Baltimore, he would have said, yes, it's much better to take the cargo off now rather than have to get all the way to the Panama Canal and then do this exercise of lightning. But the Court of Appeal said the vessel was not unseaworthy. Why? Because the defect was not an attribute of the vessel herself. It was not part of any innate quality of the vessel. And we say this case shows why there is a prior question and that the McFadden test is not sufficient. As Lord Justice Griffiths said, this is a case of bad stowage, not unseaworthiness. It's a categorical difference. Category-based different. Bad stowage is a category-based different category than seaworthiness.
They completely overlap.
Sorry?
Bad stowage and unseaworthiness completely overlap.
Yes.
If a vessel is badly stowed, it may well affect her seaworthiness.
And that is a good example of where, if in fact you have an error such that she becomes unstable, that's an attribute of the vessel. If she's actually unstable, that's an attribute of the vessel. Another example, and we come on to it on the bad stowage cases, which is if the cargo is liable to damage the vessel itself, such as you stow a container containing explosives that weren't declared, that the vessel is unseaworthy because of the risk to the vessel herself. It becomes innate to the vessel herself. And these are the sort of distinctions you'll see in the cases that have been drawn. Now, we say the principle about it being an attribute of the vessel is well established in 3 different lines of English cases and also in the US authorities. And the line of English cases are, and I've set them out in my roadmap, they're what are called the porthole cases, the equipment cases, and the bad stowage cases. And if I can do a whistle-stop tour through some of these authorities. The starting point is...
Before we embark on the whistle-stop tour, what's the proposition you're seeking to derive from these cases?
Lord Justice Flo, in our case, considered the attributes test that Lord Justice Phillips put in the Apostolis to be arguably a gloss, and that the defect didn't need to be an attribute of the vessel, and that he was attracted to my learned friend's submission that all you do is ask the McFadden question: would a prudent owner send his ship to sea? And if that determines everything, and whatever the defect is, it doesn't have to be an attribute of the vessel. And that was seriously doubted. It was said to be a gloss, and Lord Justice Flo seriously doubted it. And what we hope to show by these 3 line of cases, it's not a gloss at all. It's been well established for 100 years that a defect in the vessel to make her unseaworthy has to be an attribute.
How do you decide what's an attribute? Is it just a matter of convention? I mean, you can't just sort of, no good just thinking about it. Either crew an attribute or a piece of equipment. No sort of answer out there in the world, is there? It just has what makes something an attribute or not. Not whether it's fixed to the ship, we know that. No,
it's I think we said before, it's been said before, a broad concept. And it will be dealt with incrementally on a case-by-case basis. And, for example, overloading a vessel is not an attribute. It doesn't make up.
But what's the criterion that the court's applying when it's going to the next case, apart from looking to see whether there's been one before?
The criteria, essentially, that the court has to apply is to step back and look and see, and we would say in this case, has she got everything about her that she's in a good navigable condition, that she can be safely navigated, that issue, anything that goes to whether you can navigate her safely is an and that's our category-based distinction, because then if you go to whether an act of navigation is not an attribute, because that is not, it's extrinsic or ephemeral, it's not innate to the vessel, it's simply a set of navigational decisions that a master might take. And there's nothing wrong with the ship. The ship can be navigated safely. And it's looking at the innate issues, the innate qualities of the vessel, and whether the vessel herself is fit for purpose. It's almost going back to the 19th century cases when the implied obligation of seaworthiness was fit for purpose.
And why should the fact that the relevant chart hadn't been properly marked up, why should that not be an attribute of the vessel if the chart itself forms part of the vessel for the purpose of this exercise?
Because there was, as found by Mr. Justice Tier, there was absolutely nothing wrong with the chart, the base chart, the published chart. What happened was, in preparation for navigation, the chart was annotated with essentially navigational decisions that were going to be taken during the course of the voyage, but it's front-loading and you're supposed to take them before you leave port. And annotating a chart with those navigational decisions those navigational decisions don't cease to be navigational decisions. Navigational decisions are not an attribute of a vessel. It's not innate to the vessel. It's not its inherent quality. It is a set of navigational decisions that if you didn't write them on the chart in advance, you were going to take later anyhow. And it blurs, and I hope I've already shown the court, it blurs this distinction that is set out in the rules between a seaworthiness is making the vessel navigable and errors of navigation which that ship owners are not liable for.
Then do you go so far as to say that a passage, even if a ship had no passage plan at all, that would not affect her seaworthiness?
Yes, I do, because...
Oh, I thought you probably had to.
Well, I'll explain. It's not so much I have to, I think that's the right analysis. And if I can just explain for 1 minute. The reason I say that is because if I am right that a navigational decision, I'll cut to the chase. I was going to give you this example later, but I think now's a good time to give it. Let's just look at a navigational decision, a single navigational decision. Say you make a decision to do 10 knots in a channel. You're going too fast. If you make that decision in the channel, when you're already in the channel, it's a navigational decision. Let's say you make that decision just as you enter the narrow channel. Navigational decision. Let's say you make that decision 2 or 3 hours before you enter the channel. It's a navigational decision. Let's say you make that decision the night before when you're still in Hong Kong, tied up alongside the berth before you're going 15 hours later into Xiamen in China. Still a navigational decision. So that is just a navigational decision. Now, if you put those navigational decisions together, you call it a passage plan. But it's still just a set of navigational decisions. So in answer to my Lord's question, if you have no passage plan, the vessel is not unseaworthy, because all that happens is you don't have those set of navigational decisions which are not an attribute or an innate or an inherent quality of the vessel. The vessel isn't unseaworthy per se for not having the passage plan. She actually probably is unseaworthy because your systems are hopeless. The carrier, under her SMS, safety management system, has to have all these instructions to the crew about passage planning because it's a sensible thing to do, passage plan. It means you take your navigational decisions when you're calmer in port, you front load them, and it's a safe way to navigate. And what would undoubtedly happen in my Lord's example is, I can't conceive, certainly since the 1970s, of any vessel leaving without a passage plan. But if you never had any passage plan at all, the systems just completely broke down, and the inevitable influence.
But what attribute of the vessel
now, systems
is constituted by not having a passage plan at all, passage plan is just a collection of navigational decisions?
Because it's well established, and we've not in any sense sought to go behind this, that instructions to the crew and systems in place on how to properly use a vessel, operate a vessel, are part of the attributes. So systems, for example, the SMS, which is about 2 lever arch files worth of instructions to a crew, you've just got a fraction of them in this bundle. The instructions given to the crew and the systems adopted and in place are an attribute. We accept that. So, and that is why I go, and I'll do it in application, but that is why I say, at the end of the day, when it comes to what does a carrier have to do in regards to passage planning, he has to make sure that vessel has everything that she needs to be navigated safely. He has to have charts, compasses, ectis, all of that. He has to make sure the vessel has a competent crew. He has to make sure that there are systems in place so that the crew know that they have to passage and how to passage. And then those systems require him to audit passage planning and make sure that the systems are being performed. All of that we accept is within the role of a carrier to ensure that the vessel is seaworthy. What we say is, when it then comes to the navigating crew writing a passage plan that ends up to be defective because it says we're going to do 10 knots in a channel when you should only do 6, that is an act of navigation, and that is not an attribute of the vessel, and that is not something that renders the vessel unseaworthy.
But in this instance, the amendment, the notice to mariners says numerous steps were less than charted within the approaches to Chiang. Isn't that an amendment of the chart?
No, with respect, it's not, for 2 reasons. Firstly, you'll remember the chart didn't need amending. There was no notice to mariners that says you must now amend the chart. Nowhere said you must amend a chart to either change the depths or those depths that were set out as examples, or put a warning at the top of the chart. All the chart was required was amend the chart to say, instead of looking at this old notice to mariners, look at this new notice. Firstly. Secondly, as the judge himself found in this case, there were a number of ways in which you could reflect that warning in the notice to mariners. You could hatch out the chart, you could write it in the passage plan, you could write it at the top of the chart. The judge heard all the expert evidence and he said, I think the best way would be to write out at the top of the chart. But he said do so as a matter of passage planning. And you would, because as a matter of passage planning, it was a sensible precaution to warn the master, by the way, don't leave the channel. And he said the master should have written that as a matter of passage planning. There was nothing wrong with the ship. There was nothing wrong with the chart. There was nothing wrong with the crew. They were competent.
But following up my lady's question, is it really a decision about navigating the ship? What is it? I mean, it doesn't determine what the master's going to do at that stage at all. That the decision was that he was going to beam down the fairway, wasn't it?
I agree with my lord and my lady that actually the facts of this case are a little harder in one way, because the decision in most passage plans will be go this route, take this course, don't go over this shoal, do this speed. In this case, I accept that the decision, or rather the non-decision, was write a warning at the top of the chart so that when you're navigating, you have it there and you don't have to look at the notice to mariners. But that is an act of navigation. It's not an inherent quality of the vessel. It's not innate to the vessel herself. It's not an attribute of the vessel. The chart, and my lady's point is this, the chart isn't defective, because if I'd gone out that day and bought a brand new chart, it would still have been that chart. It didn't, my clients had equipped the vessel with the best chart they could do. They equipped her with the best chart you could buy. There was nothing wrong with the chart. It's just as part of navigating and the science of navigation, the judge held that it would have been good to either hatch out And that would be a navigational decision. Hatching out no-go areas is a navigation about where not to go. He just said that would make the chart look busy, so why not write the warning at the top? And your lord, my lady and my lord's decision in this case has to apply for all cases. Are we going to say that actually, if you say do 10 knots down a channel, and then you should only do 6, the passage plan is defective, and therefore the vessel's unseaworthy? The decision has to work in all cases, not just as it were this case. We took a bit of a digression there. I'll take the review of the cases a little more swiftly now. What I'm going to do is just explain to you that there are, I hope, 3 lines of authorities that go to this attribute. And essentially show the sorts of things that do not render a vessel unseaworthy. The starting position of the porthole cases.
I think you can take this very quickly.
I'll take this very quickly. It's the Steel and State Line case, and let me just summarise it rather than take you to the cases. Basically, Steel and State Line, which is the House of Lords decision, which then was applied by the Court of Appeal in Dobell, and was also applied in 2 Supreme Court cases in America called the Sylvia and International Navigation and FAR. Let me just summarise the porthole cases so we don't need to go to them. What it says is, you have a porthole. If you go to sea with the porthole open, but it can be easily closed when it needs to be closed.
Of course, this is a porthole that's very close to the waterline.
Correct. Correct. So if you go to sea with a porthole open, which can be very easily closed, you've got a hole in the side of your ship. There's an open, but it's not a defect in the vessel. She's not unseaworthy. It's not an attribute of the vessel because it can be very easily closed. And therefore, going to sea with an open porthole does not render the vessel unseaworthy. Now, where it gets tweaked in Dobell is if you have an open porthole, but it's now obstructed by cargo, and you can't get to the open porthole, shut it swiftly and easily when you need to, now you have a defect in the vessel because you have a hole in the side of the vessel, and it's become intrinsic to the vessel. It's innate to the vessel because you now can't get to that hole and you have a hole in the side of the vessel. And it's that distinction in the porthole cases between essentially it's not a timing issue. It's not when did you leave the vessel? Was there a hole in the side of your ship at the commencement of the voyage? It's not a timing issue. What it is it's an attributes issue. If you can close the porthole easily, you don't have a hole inside of your ship. You have a porthole, and it's got nothing to do with timing. The second line of cases are the equipment cases, and I'll take these quite quickly. What I'll actually do is take you out of order. I'll take you to Headley and Pinckney first, because this is actually a case that's worth turning up. If I can ask you to look at Headley and Pinckney, it's at 2069 of the bundle, which you'll see at tab 119. Now, this is a good example, actually, of what I'm trying to... looking at the head note, a ship was sent to sea with stanchions and rails on board, but not ship that's erected. So the stanchions and rails were not erected as they ought to have been, so as to raise the bulwarks at a certain part of the to the proper height. A storm came on, and the seaman engaged in performing his duty on deck fell overboard in consequence of the neglect to ship the stanchions and rails, and it was not safe for the crew that the ship should leave port with the stanchions and rails unshipped. Now, what's important in this case is it's under the Merchant Shipping Act, and one sees on page 2073 that there was a continuing obligation of unseaworthiness. So this case is actually quite a good case because you can now put to one side this whole temporal issue because it's a continuing obligation of unseaworthiness. Now the case is an important authority. It shows that there's a distinction between a vessel being fit for purpose, i.e. seaworthy, and B, the use of the equipment, by the crew, and the obligation, there are two categorically very different points. Now, it's what's important in this case is the obligation of seaworthiness applied throughout. Now, if one looks at page 2074, I'm picking up from the bottom of that page, you'll see they cite Steel and State Line. Lord Herschel, the Lord Chancellor, says, in the case of Steel and State Line, came before your Lordship's house, the question arose whether a vessel which started on a voyage with an insufficiently fastened porthole through which the sea burst, damaging the cargo, was in a seaworthy condition. Voyage. Lord Blackburn expressed the opinion if the port was in place where it would be in practice left open from time to time, but was capable of being shut if required, the vessel could not be said to be fit to encounter. If when bad weather threatened it was not shut, that would be negligence, crew and not unseaworthy ship. My lords, I entirely concur with the view. It's quite clear that if this view be correct, the Prodano, which is the vessel in that, was not unseaworthy at the time she left. After she left, her hull and equipment remained precisely what they were at the time of departure. She was in all respects efficiently equipped. The fault was in not making use of the equipment which had been furnished. Then he goes on to say in the top of the next paragraph, under circumstances such as these, I do not think it can be said that there was a failure to keep her in a seaworthy within the meaning of the enactment. So even when the weather got up and they still didn't erect the stanchion, she wasn't unseaworthy because all the equipment was on board and it was simply negligence by the crew. And we say there's no difference actually, essentially with this case. The vessel is fully equipped. Going back to my lady's point, that she has the best chart available, the passage plan. You've got all the equipment on board. Even in a case of a continuing obligation of seaworthiness, if the crew doesn't use that equipment, then it doesn't render the vessel unseaworthy. And that was made good by also in a later case, Madras, which you'll see then, I won't take you to it now, but Lord Justice Scrutton in Madras says something very similar in that case, where he says if you've got all the equipment on board and the crew simply just don't use it, it's not an issue of unseaworthiness. So they're the equipment cases. And the third line of cases I was going to take you to is the...
Well, if you just pause there, the case may be helpful in the distinction it is drawing between whether there is a defect in the ship or its equipment itself, on the one hand, and on the other hand, whether they have been properly used by the crew during the course of the voyage. And if you look at it that way, then is the failure to annotate the chart, which forming part of a passage plan, which the judge criticised in our case, does that not find itself on the ship and its equipment side of the line rather than the way the ship and its equipment are used by the crew during the voyage?
I agree eventually the court is going to eventually have to come and decide whether a passage plan falls on the side of the line of is the vessel navigable and has she got all the equipment, or is it going to fall on the side of the line is it's just an error in navigation? And that is essentially what's going to happen. So what I'd like to do is maybe just go ahead actually, and just deal with that whole point now. I may or may not come back to some of these authorities, but I've set them out in my written case, and I've set them out in our roadmap. We say from those legal authorities, it is established that seaworthiness is a quality of the vessel and is concerned with the vessel's attributes, and that there is a category-based distinction between defects going to seaworthiness and certain other categories of defects that don't go to seaworthiness, but they include, for example, navigation. Now, there is a degree of common ground between the parties in this, and owners accept that a vessel with a defective passage plan may, in some circumstances, be unseaworthy. We accept that. But the parties are at odds as to why. Owners say a vessel with a defective passage plan will be unseaworthy if it results from incompetent crew, inadequate systems, insufficient equipment supplied by the carrier, such as charts and nautical. And that was the approach taken by Mr. Justice Steele in the Terepo, which I've just jumped over, but one can see it. Cargo interests go further, and they say a defective passage plan itself renders the vessel unseaworthy, which was accepted by Mr. Justice Tier. Now, we say that short-circuits the analysis, and it becomes irrelevant then whether the crew were competent or the vessel systems were adequate. Liability turns solely on whether the passage plan was defective and nothing else. And therefore, another way of encapsulating the appeal is to ask whether Mr. Justice Steele's approach in the Terepo was right, or whether Mr. Justice Tier's approach in this case. Now, I've already done my first proposition, which is a navigational decision is not an attribute of the ship. I've done that first proposition because I've given you the example of doing 10 knots when you should only do 6 knots in a narrow channel. And if you make that decision when you're in the narrow channel, that's a navigational decision, and it doesn't lose its character of being a navigational decision just because you make that decision before you enter the narrow channel, or you take that decision 3 hours earlier, or you take that decision 15 hours earlier when you're alongside berth in Hong Kong. It's a navigational decision. The speed you do is a navigational decision. My second proposition is that a passage plan is no more than a record of navigational decisions. Now, therefore, it's not an attribute of the ship and not capable of rendering the ship unseaworthy. And we've already looked at the nature of passage planning and what it involves. And if one considers, for example, actually, before I do that, I'm going to move on and just deal with the 3 ways in which it's been said in this case that despite that submission that it's a series of navigational decisions, it does still render the vessel unseaworthy and is an attribute. Now, the first one is the defective chart point. Now, as we understand the argument, it says passage planning involves making annotations on the nautical chart, stage 1. Stage 2, a defective passage plan means there is a defective working chart. Stage 3, a working chart is an attribute of the ship. That seems to be the argument. Now, that's the respondent's notice point that was found favour with the Court of Appeal. They say that just as a failure to correct published nautical charts can render a vessel unseaworthy, so can a failure to mark a working chart with proper annotations as part of passage planning. They say it cannot make any difference to the result what process led to or was supposed to lead to something being written on the chart. And that's really the heart of the questions I think I've been getting from the court in the last 10 minutes. We've explained the difference in our written cases, paragraphs 31 to 43 and 138. I'll just emphasize a few more points here. The critical difference is that updating the published chart does not, when you update a chart to make sure that she's fit for use, you don't record any navigational decisions or intentions. It's merely the process by which the charts are brought up to date so that they look like a fresh copy, just as if a hydrographic office had provided you with a brand new one at the start of the voyage. If the carrier elects to discharge his obligations by asking his crew to update the charts for navigation, rather than ordering new charts, that's his choice, but obviously he's still liable for it. Therefore, we make the point that if 100 ships leave Jiangnan, their base chart should all be the same. The published charts will not change during the voyage. We say, on the other hand, passage plans are all different. The other way of putting it is that a passage plan, we say, is not an attribute of the vessel. It's merely a manifestation of the master's ephemeral intention. And this is because passage planning is about navigation and navigational intention. Now,
is it right, though, to treat passage planning in that sort of all or nothing way? It's well established that a working chart will include both an indication of your navigation intention, that is, the track that the ship's planning to take, the waypoints and so forth. But it will also include, presumably against the risk that for some reason the ship may need to deviate from that, warnings in terms of no-go areas.
yes.
Why does the hatching of a no-go area on a chart, how does it fall within your definition? Well, it's just a navigational decision. It seems to me it's not. It's saying, in case you have to change your navigation, bear in mind you shouldn't go here.
Yes, correct.
But that's not a navigational decision at all, is it? It's indicating in a more graphic way than the chart might otherwise do where it would be dangerous to go.
I agree with all of that. And what I agree, in particular, I agree that as part of the act of navigation, you don't only decide where I am going, you decide where I'm not going. And you record on the chart where I am going, and you also record on the chart as a matter of safety where you should not go. These are all matters of navigation. It doesn't matter whether it's a positive decision or an absence of a decision. Put another way, marking a no-go area is still a positive decision about where you're not going to go, where are danger areas. So as part of the science of navigation, the master will take a view with his second officer in advance, we shouldn't go here, there or wherever. And he will annotate the equipment provided by the carrier, the chart, and he'll annotate it and go, on this voyage, I think we shouldn't do this and we shouldn't deviate here and we'll hatch out these areas. That is just as much a decision because it's using the science of navigation and his judgment as a navigator to decide how he's going to navigate. And we say that is looking again at the rules and the scope of the rules. That's out with the carrier's obligation under Article 3.1 to properly equip the vessel. If you go back to 3.1b, a carrier shall make the vessel seaworthy and shall probably, I think the words are equip, supply and the like the vessel. He's properly equipped the vessel. He's given the navigators everything they need to navigate safely. The fact that the navigators, for example, my Lord's example, imagine if one hatched the wrong area. So you hatch out an area and say, don't go here, but in fact you hatch out the wrong area, you should have hatched out a different area. And therefore there's a grounding. That's just a navigational decision. It's not inherent to the vessel. She could have been navigated safely. She's in a navigable condition. It's just the master navigated negligently. Why should it matter that it was written down in advance?
But surely before you decide which route to take, you've got to mark up the plan to see where it's possible to go.
Correct. I agree. And therefore, for example, if you mark up your chart and you draw your course line and it takes you over a shoal, which you don't have enough depth to safely go over, that's a navigational error. The fact that you've drawn it on your chart doesn't mean your chart is now defective and your vessel is unseaworthy. What you've done is, when planning your route and taking your vessel, you've gone over a shoal area and you're going to ground.
Wasn't quite the point I was making, that in order to decide which way to navigate, you've got to have a plan which shows all the information which is available to you.
Yes, and they have that. They have the chart and they have the notice to mariners. And the chart says, look at the notice to mariners. And the notice to mariners contains a depth warning. What the judge held, and this is why those paragraphs 67 to 70 of his judgment are very, very important. What the judge says is, as a matter of passage planning, you could have hatched out the sides of the fairway saying no-go areas, but he took the view that that would make the chart too busy. And therefore, he says, well, the better way is to write the warning at the top of the chart. Now, let me test it this way. Well, we say that is a matter of navigation, and it's my lady's point. You have to decide what is a safe route, and you've decided it by hatching. But that's a navigational decision. Let's test it this way. Nobody in the courts below, and certainly not at first instance, did anybody argue that because Her Majesty's Hydrographic Office thought it was good enough to have the warning in the notice to mariner, didn't themselves print it on the chart, or didn't require in a notice to mariners to instruct the crew to update the chart by writing it out. Nobody said, well, the published chart was defective, the vessel was unseaworthy. The published chart wasn't defective, and it still hasn't been amended. The public chart is the equipment the carrier gives so that this vessel can be navigated safely. What's happened is that in making navigational decisions and planning your passage, they didn't hatch out the right part of the chart, or they didn't put the notice at the top of the chart. And what we say essentially is that that just simply is an error in navigation. And if you now make that vessel unseaworthy, you are really changing that balance of the bargain struck in 1924 between seaworthiness and navigation, and you are now moving into seaworthiness errors that were navigational errors, which were for the cargo to insure against. And you are undermining that balance. And I was going to give the court another example, which is if we go back to, for example, a speed example. You may remember that there's two parts of a passage plan. There's the written document and then recording some of it on the chart. If you write in the written document to go through a channel or a canal too fast, and you say speed in this canal 10 knots, and you put it in the written document, doesn't render the chart, nobody would say the chart is defective. Why does it matter and now say the chart is defective if against the canal or the channel you write on the chart 10 knots rather than 6 knots? You haven't rendered the chart defective. What you've done is that navigational decision could have been written somewhere else in the passage plan pro forma document. So what we urge the court to do is really grapple with this question about navigational decisions, because your lordship's and my lady's judgment is going to have a significant impact on carriers going forward if their passage plans can be scrutinised. And for example, even if it's not written on the chart, but in the passage plan pro forma document, a decision is written to do something that later causes the vessel to ground or collide or something happen. That's going to mean that vessels are unseaworthy and the apportionment of responsibility and risk and insurance has dramatically moved. I don't know if that would be a good time to stop, because what I would do then is change the order of my submissions now over the short adjournment, because I've slightly jumped ahead of myself.
Certainly. Well, we'll adjourn now and resume at 2 o'clock.